Good afternoon, ladies and gentlemen. Congratulations on surviving lunch. It's always a step forward. So we are going to reconvene, and we are going to shift our focus again to the Fiscal and Administrative Working Group. I had to think there for a moment, Justice O'Leary. And are you going to introduce Justice O'Leary, Judge?
Not only am I going to introduce her, but I'm looking forward to it. To present this relates to Concept 8, explore court reporters' dual status, compensation discrepancies, and ownership of transcripts. To present the concept relating to exploring court reporters' dual status, compensation discrepancies, and ownership of transcripts, I would at this time like to introduce Justice Kathleen E. O'Leary, Presiding Justice of the Court of Appeal, 4th Appellate District, Division 3, and Chair of the Fiscal Court Administration Working Group. Justice O'Leary.
Thank you, Justice McGinnis. Because I do chair the committee, and the final three items this afternoon are Fiscal Administration Working Group concepts, I thought I would just introduce kind of what the charge for our working group was. We were addressing what I am calling the business side of the court. Courts in our adjudicative role decide cases based on precedent, yet when it comes to business matters, we need to be progressive and innovative. Healthy organizations must be continually reinventing themselves and changing procedures and policies and methods of operation to keep up with the times. Experts in operational management often say, if you aren't moving forward, you're falling behind. And the California court system can't afford to fall behind, which is, I think, one of the reasons why the chief felt that this work was so important. But despite the fact that this might be a good thing to be doing, being internally critical of our own operations, change can be very difficult. And I've been on the bench for just about 35 years, and I remember the change from block grants, which we did in the 60s and early 70s. That was very difficult for people to understand. We were no longer going to be funded in that fashion. But I like to think of change as being an opportunity and not a threat. But some of the comments we've received, I think, suggest that there's a great deal of fear out there and that we are threatening the status quo. But I don't think any of our concepts suggest that we're going to throw the baby out with the bathwater. Discussion of these very difficult concepts is critical to the future of justice in California, because it's very clear that we can't count on our sister branches of government or the public to keep throwing money at the judicial branch. Mike Bradley, I thought, said something very interesting. He said, ABOTA certainly welcomes the opportunity to participate in the Open Courts Coalition, but knowing that the court is doing this critical self-evaluation will make it easier for them to lobby on behalf of the courts. So I think the concepts that we're going to be presenting this afternoon are concepts that are intended to identify smarter ways to do business, to increase the overall effectiveness of the justice system, and to make our delivery of these services cost-effective. The concept that I'm presenting is explore court reporters' dual status, compensation discrepancies, and ownership of transcripts. Why are we considering this? Court reporters are uniquely situated as court employees and independent contractors. The cost to the courts to provide court reporters and for certain types of cases to purchase original transcripts and copies is considerable. Courts provide court reporter service in most courts, and in fiscal year 14-15, the courts paid $196 million for court reporter compensation, and that cost was partially offset by fees paid by parties in civil proceedings. In addition to covering compensation costs, though, for court reporter services, courts must also pay for transcripts on appeal in criminal, juvenile dependency, and juvenile delinquency cases. The cost of these transcripts, again, using fiscal year 14-15, was $19.3 million. The cost to the courts for the purchase of transcripts varied among the courts, ranging from $0 to over $6 million annually. Naturally, the cost for transcripts was higher in larger courts. However, the cost also varied between courts of similar sizes. As an example, the cost to purchase transcripts with courts for courts with 4 to 11 judges ranged from $20,363 annually to $323,360 annually. The cost to purchase a transcript from a court reporter is statutorily set by the government code, and there's pending legislation that would increase the transcript costs. Under current law, court reporters own their own transcripts, which is why courts must purchase transcripts from their court employee reporters. Court reporters may be employees of a court, independent contractors of the court, or hired by litigants as official pro tem reporters in civil cases. Most court reporters are court employees, and the cost associated with this group of reporters is a concern that the Commission is exploring. Court employee reporters occupy a unique dual status. They are considered court employees when they take notes in recording a proceeding, but they operate as independent contractors when they produce and sell the certified verbatim transcript. So court employee reporters receive a salary from the court as court employees for recording the proceedings and earn separate income as independent contractors from the sale of the transcripts they produce from their notes. This dual status has led to disagreement in some courts. Many courts have a practice or policy of allowing court reporters to work during the court day on independent contractor tasks involved in preparing a final transcript, such as preparing the index, determining the due dates, preparing requests for extensions, and other efforts to ensure that the record is timely and accurately prepared and submitted. This generally only occurs during court hours when a court reporter is not needed in a courtroom to take notes in recording a proceeding. A court reporter who does such work is thus acting as a separately compensated independent contractor while simultaneously working as a court employee. Salaries of court reporters vary among courts, and reform could result in more uniformity, but still appropriate salaries for court employee reporters. The salaries of court-employed reporters received for attending the proceedings and recording and taking notes of the testimony and statements vary substantially among courts. Comparing the beginning and last step of the reported salary ranges for court employee reporters revealed that monthly salaries vary from $3,654 to $4,897 at the first step, to $8,978 to $9,509 at the highest step. The reasons for the disparate compensation are unclear, as they do not appear to be related to court size or differing duties or assignments, and the disparities are greater than would be expected to account for geographical differences in cost of living and labor. In addition to receiving salaries, court employee reporters also receive benefits as court employees and have the potential to earn transcript income as independent contractors. So we factored in average salary, average benefits, and average transcript earnings. And that revealed that court employee reporters may make an estimated average yearly income ranging from $90,379 to $194,809. Those are the averages. In terms of actual estimated yearly income, there's considerable variance in estimated yearly income among courts of similar size, and this variance increases when you consider the potential income for high earners. Some court employee reporters with high transcript earnings earn yearly incomes in excess of $200,000 annually. I'm on the wrong concept here. I'm stealing my karate thunder. Okay. Slide 5. That's slide 5. Yeah. Goals and strategies. Transcripts could be prepared by court employee reporters as part of their court employment. In that case, the court would own the transcripts. Other ownership arrangements could also be considered. For example, when it comes to criminal dependency and delinquency cases where the court itself has to purchase the transcripts on appeal. The overarching goals of this concept are to reduce the cost to trial courts of the purchase of transcripts and the right to reproduce transcripts. If transcript preparation and related duties becomes part of a court employment or court employee reporters' employment duties, the Commission recognizes there likely will be a need for more court reporters. That being, while some reporters are preparing their transcripts, they won't be in the courtroom. We'll need more employees to fill those vacancies in the courtrooms. And some costs for transcript preparations would need to be shifted to the courts because there would be expenses incurred in the course of the court reporter's employment preparing transcripts, and that cost would have to be borne by the court. So this concept would require an analysis of the cost of all transcripts, originals, and copies purchased by courts from independent contractor reporters and the projected costs and salaries for employee court reporters to produce the same transcripts on court time, as well as transcript preparation-related costs. The goal of the Futures Commission is to catalyze change. Our charge from the Chief Justice was to take a fresh look at the challenges the courts face and consider concepts that could increase long-term efficiency, fiscal stability for the judicial branch, and increase access to justice, and basically improve the way we serve the public. I think this concept is consistent with that, with improvements in technology over time that make the production of transcripts less time-consuming and make it easier to copy and transmit them electronically. It may be time to change the way transcripts are produced and owned. Court reporters provide a valuable service to the courts, and yet, as court funding declines, some courts have opted to reduce or eliminate court employee reporters, leaving it to litigants to hire non-employee court reporters or to go without a record entirely. And the lack of court reporters in a courtroom present even greater challenges for self-represented litigants. So a change in the method of the preparation of transcripts and the ownership of transcripts has the potential to reduce transcript costs for the judicial branch, to allow the judicial branch to consider a cost structure for transcripts that would provide litigants with a realistic opportunity to purchase transcripts within their means, and allow local courts to employ more court reporters. So we'll go to the public comment.
Our final presenter this afternoon is Judge Robert Trent Acosta, who is a Superior Court judge from San Diego and the chair of the Commission's Technology Working Group. He is going to present a concept having to do with digital recording of court proceedings and the provision of an official record. In addition, there are two other concepts that the Technology Working Group is exploring, and while that work is in process, additional public input will, in the form of written feedback will be solicited in mid to late September. Those two concepts, not to take away from the presentation he's just about to make, but those upcoming two concepts have to do with establishing an ongoing innovation lab to enhance a culture of technological innovation and experimentation to see what works in various laboratories around the state, and expanding the use of technology to improve efficiency and to enhance access. So those are two ideas that are coming soon to a theater near you. But at the moment, Judge Trent Acosta is going to address digital recording of court proceedings. Judge?
Thank you, Justice Corrigan. And Justice O'Leary, if I may ask you to please help me with the PowerPoint. I am going to be addressing Concept 10, which is digital recording of court proceedings to provide an official record. And the Futures Commission, next please. The Futures Commission is exploring existing and emerging technologies to prepare an official record of court proceedings in a digital format that would be cost-effective, that would be accessible to the litigants, the attorneys, and to the court, and would be searchable for ease of reference and greater convenience and usability. Next. Why is this concept being considered? A record of court proceedings is a fundamental component of access to justice. court records of proceedings show the parties court records will show what the parties said and what the court did. It will not give the public anything other than the final outcome. We are striving for a complete and accurate record of the court and party actions. Verbatim reporting of proceedings by a court reporter is only required in some types of cases: felonies, juvenile proceedings, domestic violence, and elder abuse restraining orders. In other case types, notably civil and family, a record of proceedings by a court reporter is not required. In fact, in these proceedings, the use of electronic recordings as the official record is prohibited except in misdemeanor cases, infraction cases such as traffic citations, and limited civil cases. The practical effect of this is in family law cases in particular, where there are a high percentage of self-represented litigants. It is difficult for the parties to understand what has happened. It is difficult without a record for them to put together a order that is consistent with the court's ruling, and it has been shown that effectuating an appeal without a court record is difficult to impossible. Next. Currently, technology has advanced where digital recording systems can now provide quality audio, video, and an accurate record of court proceedings. In our work, we have seen demonstrations both in active courts as well as in the technology laboratories, mainly in the Silicon Valley companies, of the following. Digital recording provides high-definition recording and transmissions. The cameras are now small, they are unobtrusive, and they can be programmed to give a 360-degree field of vision in the courtroom. The audio quality has similarly advanced by a mile. There are motion and speech-activated microphones. There are noise-canceling systems and noise suppression so that the ambient noise can be eliminated or reduced, and the speaker can be heard clearly and crisply. In addition, audio now has separate channels for each of the speakers. So if we have a situation that occurs commonly in court where people speak over one another, the separate audio channels, when it is being transcribed, can now be pristine. Both speakers can be heard, and there isn't the typical unintelligible overspeak that we have experienced in the past. The digital nature of this makes storage inexpensive. Storage is abundant. And, of course, the digital nature of this makes it searchable. When one is using the court record, a few keystrokes, keywords, or phrases, you can get right to the issue at hand. The ability to slow down these digital recordings, if one is going to transcribe, is going to make this easier to get a transcript. Next. What we experienced was many of the problems that existed, many of the frustrations that we've all felt with the old recording systems can now be eliminated or reduced dramatically. The actual record that can be produced is not simply going to be what is said. It will be what actually happened in the courtroom: audio, visual, and a transcript. In addition, Trial courts are now experiencing technology in many forms. One instance is the use of body cams by police. This video can now be seamlessly put into the court record because of the digital nature of the court record. Next. We all know that budget cuts have reduced court-provided reporters. Unfortunately, with civil and family, where court reporting is not required by law, they have been hardest hit. In family, where there are a great number of self-represented litigants, they have borne the brunt of a lack of court record. As I've said, access to justice is one thing, having meaningful justice is another. An inability to have a record to appeal is simply not acceptable. Next. There are better methods to obtain transcripts to make good use of modern technology. We are concerned that without adequate court funding in the future, we will not be able to replenish our supply of court reporters, and we will need to use electronic and/or digital recording in those proceedings so that the parties can have a fundamental right of a record. Next. We would recommend legislative changes to permit a pilot program that would allow courts to use digital recordings of proceedings to serve as the official record in those cases in which court reporters are not currently mandated. And that would conclude the summary of our concept, and we will now open it to public comment. And
welcome to AMVSR LLC, your 21st century remote court reporting service, introducing ASR Transcriptor, 100% automated real-time speech recognition transcription. I'm Steve Hubbard, a former United States District Court reporter, gone rogue, introducing transcription technology that is immediate across all 24 time zones to anyone and everyone. Join me for a few minutes and witness only what you thought was possible in a Star Trek movie. When we're done, you will start to rethink and retool your war chest when litigating. Your clients come first, and we can show you how to save up to 80% in your transcription costs. Settle a case without even ordering the final certified transcript using our interactive 100% verifiable solution using our automated speech recognition technology. And when you need a final certified transcript, we can deliver that too for one flat price for a PDF file that you can share with every other party and share the cost. No copy sales to compound the bottom line when somebody at a motion tax costs has to pony up on paying everybody else's court reporting fees, including your own. Chris, Michael, this is the H6 Zoom Handy Recorder. The one I used was the H5. An earlier generation. And with all the paraphernalia you saw me with, including the lapel mics and cables, it costs around $500, all fitting quite neatly in a briefcase. After you learn how to set it up, and I will teach your IT personnel so they can teach you and your associates, you will experience for the first time Court Reporter on Demand, anywhere, anytime. Whenever you find yourself in a courtroom that does not use a court reporter, only sophisticated digital gooseneck mics like these, and they are recording at very high quality, minimum 320 kilobits per second, order the audio CD or the DVD movie of the hearing. Instead of ordering the official transcript at first, have us create a working rough draft for just $150 for the whole day's proceedings, delivered to you either the same day or in the morning. We can take a 7-hour audio or video and convert it to a transcript in 30 minutes. If you want the rough draft synchronized to the video or audio, add $1 per recorded minute and share that file with all the parties and share the cost. When you want a live real-time transcript sent to your smart device where you are and or to your colleagues, no matter where they are, then you need to install in your smart device Periscope, as well as having the witness and the lawyers using high-quality lapel microphones pinned up as close to their throats as possible. The other end connected to a hub that is connected to those lapel mics, and the hub is then connected to the audio in port of your smartphone or tablet. And when you are running in the non-public mode of Periscope, we here at AMVSR LLC are watching the proceedings and hearing, capturing the outstanding streaming audio that goes to ASR transcriptor that ultimately delivers your real-time transcript. Periscope is 100% secure. Only those parties that you want to see the proceedings will see and hear the deposition, and they will not be able to share with non-approved viewers. Of course, we will run a couple mock depositions at first to make sure that your IT personnel know exactly what to do, so they are able to train all the lawyers and paralegals in your office. It is Apache OpenOffice that we use to splash the real-time transcript onto the screen here in the office and then upload the multimedia transcript to Google Drive and share the link for those who have access to this transcript to view and or to download. Apache OpenOffice is an open source program and a license is not required. So visit their website and download the latest version for your smart device and PCs or Macs as the case may be. You can always save the file later to a Word file.